The next case to come before the court is Lillian Robertson, the Mental Health Addiction and Recovery Services Board of Lorain County. Each party will be given 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time for rebuttal, please let me know, as I'll be keeping track of the time, and I'll try to let you know when you go into that rebuttal time. The arguments are being recorded, so please stay behind the podium, introduce yourselves, keep your voices up. You should not use the names of children or minors or victims during your argument, should that be relevant. We have read your briefs, and we're ready to proceed when you are, so we just asked the appellant, would you like to reserve time for rebuttal?
Yes, I'd like to reserve 3 minutes, please.
Okay. Very well, then you may begin when you're ready.
May it please the court. My name is Karen Wu, and along with my co-counsel Maria Smith, we represent the appellant Lillian Robertson. We are asking the court today to reverse the lower court's decision and to remand it for an evidentiary hearing for 3 main reasons. First, that the court used the wrong document to calculate when the 2506 appeal time began to run. Second, that the court failed to find that Ms. Robertson was entitled to a reasonable accommodation request pursuant to the Fair Housing Act. And 3, that Ms. Robertson was not provided with due process under the 14th Amendment. Moving to the facts of the case, in 2020, Ms. Robertson received a subsidy for the Shelter Plus Care program. The Shelter Plus Care program is a federally subsidized housing program for people exactly like Ms. Robertson, chronically homeless individuals with mental health issues. The program is funded by the U.S. Department of Housing and Urban Development, or HUD. And in this case, HUD awarded funds to the Mental Health and Recovery Services Board of Lorain County, or the MARS Board, for the Shelter Plus Care program. Now, there are 3 main parties in the Shelter Plus Care program. The first party is the program participant, Ms. Robertson, a disabled tenant who receives behavioral health services and has no income. The second party is the MARS Board, a political entity of subdivision. And the third party is New Sunrise Properties, who's the private landlord. Now, the political entity signed a contract with the private landlord to pay 100% of Ms. Robertson's rent due to the fact that she did not have income. And starting in July of 2022, the private landlord sent Ms. Robertson notices about the need for recertification. Around the same time, Ms. Robertson's medications became inadequate and needed adjustment. On October 26, 2022, the private landlord sent Ms. Robertson a letter stating that once her subsidy terminates on November 1st, 2022, you will be responsible for the full amount of rent of $732. Unfortunately, Ms. Robertson did not sign her lease. And on December 13, 2022, the private landlord filed an eviction against Ms. Robertson. On February 24, 2023, Ms. Robertson then submitted a reasonable accommodation request to the governmental entity, asking for time for her medications to be adjusted and to be able to sign the lease. On March 9, 2023, the political entity issued a decision denying the reasonable accommodation request, stating, "This is not a request for a reasonable accommodation. We consider the matter to be closed." On April 6, 2023, Ms. Robertson timely filed a 2506 appeal, and the political entity then filed a motion to dismiss based on lack of subject matter jurisdiction, which was granted by the Common Pleas Court, and it is that decision which we are appealing today. So going to my first assignment of error, the appellee's brief is arguing that the March 9th decision did not trigger a 2506 appeal. However, whether a proceeding is quasi-judicial, from which a 2506.01 appeal may be taken, depends on what law requires the agency to do, not what the agency actually does. Under Revised Code Section 2506.01, courts of common pleas may review decisions of any political subdivisions of the state. The lower court used the incorrect document to calculate when the 2506 appeal clock for 2 reasons. So first,
Is it possible that both of these things aren't final appealable orders?
the letter or the letter from the private agency and the letter saying this was already decided before?
I'm sorry, did you say, is it possible that it is
That
not?
neither one of these things are final and appealable orders.
No, I don't believe so, Your Honor. The March 9th decision from the Mars Board is a decision by the Mars Board.
It's a letter though, right? Just saying the matter had already been terminated or already been handled.
I mean, so it is in the form of a letter, but it is by a person with authority to act on behalf of the Mars Board, their attorney.
Okay.
And it's a decision because it's a final, there's no expectation that there is something going to be coming afterwards.
Isn't it a letter that just states that a decision was made at some other point?
No, that's not correct, Your Honor. Because there was, the letter from my client, Ms. Robertson, was dated February 24th, requesting a reasonable accommodation. And the response by the Mars Board is in respect to that letter. So there wasn't any sort of previous decision made, right? That's the response from the Mars Board.
Should your client have received a letter from the Mars Board that her subsidy had been terminated by them, not just one that was sent to the third-party agency?
Your question is should have?
Yeah, or is that in the record?
I agree that my client should have received a letter from the Mars Board terminating her subsidy.
I'm just saying that could be the final appealable order that we're searching for, right?
Correct, but there is none. There is no such letter. So the
So
Mars,
then maybe there wasn't an official determination then that they were terminated.
there was no official determination by the Mars Board that she was terminated. But for purposes of this appeal, 2506 indicates that any sort of decision by a political entity can be reviewed by the Common Pleas Court. And that's what we're asking the court to look at today. So going back to my argument, the lower court used the incorrect document to calculate when the 2506 appeal clock ran for two reasons. One, that the court incorrectly relied on the letter because New Sunrise is not a political entity, but a private entity, and private entities do not fall within the categories listed in 2506.01. And second, the October 26th letter was not a decision. It was a warning letter. Once the subsidy terminates on October 1st, your rent goes up to market rent. In addition, it's not a decision because it's dated October 26th, 5 days before the November 1st due date. So for these reasons, Ms. Robertson could not have appealed the October 26th letter under 2506. But the correct letter is that should have been used is the March 9th letter, because the Mars Board is a political entity and it was a decision, as I previously indicated, it was made by someone with authority, and there's no expectation that there would be another letter. The letter indicates we consider this matter closed. Moving to the second assignment of error, the lower court erred in failing to find that Ms. Robertson was entitled to reasonable accommodation pursuant to the Fair Housing Act. To establish a right to a reasonable accommodation, Ms. Robertson must demonstrate that she was disabled. Second, that the housing provider knows or reasonably should have known that she suffered from a disability. Third, that the reasonable accommodation is necessary to allow continued participation in the program. And fourth, that the housing provider refuses to make a reasonable accommodation. Ms. Robertson has established all of these elements. First, that she is disabled. The Mars Board was aware that she was disabled. By being accepted into the Shelter Plus Care program, one of the requirements is disability, and there's no dispute that the Mars Board, from the Mars Board, as to her disability during the participation of that program. Third, that the reasonable accommodation request is reasonable on its face. Federal law provides that the agency recipients are not prohibited from resuming assistance to a participant. And fourth, the Mars Board did deny Ms. Robertson's the reasonable accommodation request, stating this is not a request for a reasonable accommodation.
It's not a request. Does it say why? I mean, obviously a person with a disability can keep requesting reasonable accommodations, right?
Correct. Yeah, so no explanation is given in the letter other than this is not a request for reasonable accommodation.
Is it because the letter requested things that weren't a reasonable accommodation, but rather something that she'd already received that she can't receive again, or?
Well, so the letter doesn't state and doesn't give any reason, and the reasonable accommodation request was not asking for anything that Ms. Robertson had already asked or had already received. You know, she was asking for her medications to be, more time for her medications to be adjusted, that she'd be able to sign a lease. You know, she was asking for, just trying to make sure that her housing was stabilized. So nothing unreasonable, you know, nothing that would be burdensome to the housing provider. And so that brings me to the third assignment of error, due process. The court erred because it did not provide due process under the 14th Amendment to Ms. Robertson. Under the revised code statute 2506.03A3, Ms. Robertson is entitled to an evidentiary hearing in an administrative appeal, and it's undisputed that there was no evidentiary hearing that took place and no testimony was taken under oath. By denying her the evidentiary hearing, she is not allowed to examine and cross-examine witnesses and present evidence in support or to refute the governmental entity's position. In addition, federal regulations and the contract between the governmental entity and the private landlord require recipients of federal funds for the Shelter Plus Care Program to create a formal process, recognizing participants' rights to due process of law. As a HUD-funded recipient, the governmental entity was required to abide by these regulations. The governmental entity should have given Ms. Robertson a written notice containing a clear statement of reasons for the termination, an opportunity to present objections to an impartial party, and to receive a final written decision. The governmental entity did not provide any notices to Ms. Robertson, much less this information. In addition, the October 26th letter from the private landlord, New Sunrise, also does not inform Ms. Robertson of her right to contest raising her rent to market rent.
Counsel, was the eviction case consolidated with this case?
I did file a motion to consolidate, but it was denied, so it was not consolidated.
Is it still pending?
Yes, it is still pending. So the Common Pleas Court had granted summary judgment in favor of New Sunrise, the private landlord. And then as far as the claims involving the Mars Board, they had filed a motion for summary judgment as well. The Common Pleas Court has stayed ruling on that motion for summary judgment pending this court's ruling in this case.
And even though it wasn't consolidated, we can garner that information from the record before us? Based on, I mean, I don't think there's a dispute. I just wondered if that's still the status.
Yes, that is
Okay.
still the status.
And you are moving into your rebuttal time.
I do have a question.
Oh, yes.
Is there a formal process to request a reasonable accommodation other than a letter?
So this is the process to request a reasonable accommodation. In fact, to request a reasonable accommodation, you don't even necessarily need to have a letter or something in writing. You could do it orally. But yes, this.
And then that triggers triggers the process, even orally?
Yeah, it does. It triggers the housing provider is then required to respond to the reasonable accommodation request. I mean, obviously, preferably it would be in writing to establish a paper trail, but it is kind of like
Oh, it would be to the housing provider, not to the board.
anyone who's subject to under the Fair Housing Act.
Okay, so
It
you
is.
have to make a reasonable accommodation request to the housing provider, and then it would get to the board, potentially, if there's a denial of that reasonable accommodation.
No, so there isn't like a formal process as in like you would file something with the housing provider and then if it's denied, then you go to the board. No. So you can submit a reasonable accommodation request to any entity with regards to if it violates that person's housing. First off, if it's a person with a disability, you need to be a person with a disability, right? And then the reasonable accommodation needs to be something that's related to your disability, what you're asking for. And then, so in this case, it's to stabilize the person's housing. So there's steps in that way, if that's what you're asking, as far as like what you need to do, but it's not like a formal process where you have to like go to the landlord and then go somewhere else.
But are you supposed to go to the provider, the housing provider?
So in this case, my client did not have to do that, although she did. But however, that is not in the record, so we're not discussing
Okay.
bring that up. But
Okay. You have about 25 seconds for rebuttal. Do you want to take your time now, or do you want to?
I will insert it.
Okay, thank you.
Just let me know where I can begin.
You may proceed.
Okay, thank you. May it please the court, my name is Lee Prue and I represent the Mental Health and Addiction Recovery Services Board of Lorain County. I want to talk a lot about the law that's been referenced in the appellant's brief before getting to anything else, specifically because I want this court to focus on the sole issue that's really before it, and that is whether or not the court actually had subject matter jurisdiction to hear an administrative appeal. That's really what I wanted to focus on in my brief. I focused very, very narrowly on it. But now I want to look at some of the cases that were brought up within the appellant's brief to demonstrate why I believe those cases actually support the Mars Board position. The first one, and this is on page 9 of the appellant's brief, and that is State versus Hilltop Realtors versus Cincinnati. This case is a mandamus case. It was brought by a relator against the city of Cincinnati. And what happened in that case is the relator wanted to appeal the denial of some sort of a driveway permit. I can't exactly remember what it was. The city of Cincinnati said that the mandamus shouldn't be able to stand because the relator hadn't exhausted all of their administrative remedies, and so there was still a legal remedy for them to have, which is why you wouldn't be able to grant a mandamus. And what they said was that it was important for the relator to first exhaust their administrative remedies by filing a 2506 appeal. The Court of Appeals said that's not possible. There is a sidewalk appeals board in the city of Cincinnati. The requested appeal that took place before the city of Cincinnati in this case didn't have any provision for any kind of appeal that took place. There was nothing in Cincinnati's codified ordinances that allowed there to be an appeal from the thing that the relator was asking for. Therefore, there was no possibility for them to even file a 2106 appeal, 2506 appeal, 0.01. And therefore, they didn't have to exhaust their administrative remedies that they never even had. Similarly, the Mars Board in this case is an entity that is statutorily created under Chapter 340 of the Ohio Revised Code, where it derives basically all of its powers. It doesn't have the authority to hold hearings like this. It doesn't have the authority to make determinations with regard to mental health residents, let alone people that are receiving housing, and what they can and cannot do. It can't provide direct services with regard to reasonable accommodation. It would not have been able to do anything with regard to Ms. Robertson's medications. It would not have been able to do anything with regard to stopping an eviction case. It would not have been able to do anything with regard to getting her back involved in the Children Plus Care program. It's not something that the Mars Board has the authority, the legal authority to do, because it is governed entirely by statute. The next case I want to point out is in the appeal of Lieutenant Howard. This is also on page 9 of the appellant's brief. In this case, Mr. Howard was denied a promotion of police chief, and he sought an administrative review that was able to be done by the City of Kahana's Civil Service Commission. And that process is essentially governed, as stated in the case, by this particular section of the Ohio Revised Code, which is 124.56. What that statute says is that if the Civil Service Commission has reason to believe that an appointing authority is acting outside their authority or acting, abusing their power, that they can conduct an investigation into whether or not that's happening. So that's what he asked for. When the Civil Service Commission in that case conducted its review, they allowed Mr. Howard to present testimony and to call witnesses, and then they made their decision. The Court of Appeals said, despite the fact that there had been witnesses called and there had been testimony given, that was simply in furtherance of the investigation because the statute itself says that the requirement is for an investigation, not for a quasi-judicial hearing. So when the plaintiff claims, or when the appellant here claims that whether or not a proceeding is quasi-judicial, it depends on whether or not the law requires it and not on what has actually been done. What I want to stress to you is that the Mars Board also does not have the authority to engage in any kind of action that would give rise to a 2506 appeal either. However, I want to also mention some of the rules that Ms. Wu talked about, some of the requirements that are required for due process that are referenced in her brief under the Code of Federal Regulations, and that is providing a program participant with a written copy of the program rules in the termination process, written notice to a participant containing a clear statement of reasons for the termination, a review of the decision where the participant is given the opportunity to present written or oral objections before a person other than whoever issued the decision, and then a final notice of the decision. What I want to stress here is that none of those requirements amount to a quasi-judicial hearing. So even if the Mars Board did all of that, and even if New Sunrise had done all of that, none of it is quasi-judicial, and therefore none of it gives rise to the requirement that the Mars Board conduct some sort of quasi-judicial hearing or create a situation then where the appellant should have the opportunity to be taking this appeal.
Well, the trial court ruled that the letter was the final appealable order of untimely, and that's why the court doesn't have jurisdiction. What about that?
I'm perfectly happy to have you affirm the trial court's decision because it's a win for us.
But do you think that's a final and appealable order that even should be, there should be a time period that runs?
Well, here's my, first of all, what I'd like to say is that also, because I want to make sure I respond to your question, also in the appellant's brief on page 15, she references the case of Gorsuch Inc. versus Wooten. In that case, there's a statement that the court has issued in its opinion. It says, the due process requirements of the 14th Amendment apply to private landlords who provide Section 8 federally subsidized housing for low-income tenants. Therefore, it's evident that the court recognizes that a private landlord, even though it's private, still has to conform to these requirements that are provided within HUD. So yes, I do believe that if there were some sort of an issue that needed to be made or some sort of a request for a hearing that needed to be made by Ms. Robertson, that should have been done to New Sunrise. That's been the Mars Board's position the entire time.
Well, Counsel, to follow up on Judge Lansinger's question, because I think I read the judgment entry the same way that Judge Lansinger does. The trial court said your time for filing the appeal was after the letter, be it an appeal to Sunrise or the Mars Board. And so without, and utilizes Downey, but without analyzing whether or not whatever Sunrise did was an act by a political subdivision. I mean, none of that analysis is in the entry.
Sorry, and I understand that it's not in the entry. I believe that when we ended up doing our response to our motion to dismiss, our brief in opposition to, or reply to a motion to dismiss, we did bring up the fact that she didn't have enough time.
So
It would be my opinion that, again, this has to do with the 2506 appeal. I don't know if it's possible to suggest that a private landlord has the ability to take any action that would ever give rise to a 2506 appeal, but that's the action that's in front of us today.
So I'm just summarizing to make sure I have it right. You're saying the judge was right about jurisdiction, but for the wrong reason?
That's correct. But, well, that's the thing. I mean, if you're interested in accepting that decision and just affirming it, that's perfectly fine with me because it still constitutes a win for our client. But I would simply, then this is part of the reason that I wanted to stress this as fervently as I possibly could in my brief. There was simply no action in anything that took place here that gave rise to a 2506 appeal. And the same thing is true with the letter that Ms. Robertson wrote through her counsel to the Mars Board. Again, it was a request for a reasonable accommodation. even before mentioning that, what I want to also stress is that Ms. Robertson's letters, what we see in the record here, which is kind of scant, is that she was told to recertify, and she was told to recertify, and she was told to recertify, and she didn't. She was told that her subsidy was going to expire. She was never told that she was going to be terminated. She herself, in her letter to the Mars Board, stated that New Sunrise terminated her subsidy. So I think Ms. Robertson herself understood that her rights started when that action took place and she was no longer part of the program. So we already have concerns, which we haven't been able to determine at the lower level as to whether or not this was voluntary, whether it was actually a termination. And the only reason that I wanted to stress that we're talking about a 2506 appeal here is because I don't want the court to feel like it's obligated to start getting into some of these other arguments, like has been mentioned. There's already a case out there. Not only that, but there's also a HUD complaint that's been filed against the Mars Board by Ms. Robertson that just got filed a little bit over a month ago. And she's alleging a number of the same arguments that she's already made in her brief here, and that she's already made in her case that she brought back in June of 2023.
So we don't really want to talk about those here on this appeal, but.
That's perfectly fine. In any case, what I'd like to stress is that the action that took place toward the Mars Board in February also did not constitute any kind of an action from which an administrative appeal could be taken. It was simply a letter. First of all it did was request a reasonable accommodation under circumstances where the participant wasn't even a participant in the program any longer because her participation had ended because she allowed her subsidy to expire by view of the fact that she hadn't taken the affirmative action necessary to continue to certify herself as being part of the program. There are a number of questions, I think, as to whether or not you need to actually know the status of who she was or the status of how she would be viewed before you could possibly really understand or meaningfully argue as to whether or not she would actually have been able to request a reasonable accommodation. For argument's sake, presuming that she was still part of the program and she did still have the opportunity to request that, nevertheless, Your Honors, all that took place was a letter. There was no request for any kind of due process hearing. There was never any kind of request for any kind of due process evaluation. And like I say before, even if that had happened and the Mars Board had in fact actually gotten some sort of hearing together or gotten some sort of process together, given her the opportunity to request a reasonable accommodation, given her a request to provide evidence or provide some sort of written objections, none of that would have been quasi-judicial and none of that would have given rise to a 2506 appeal. I really do want to stress that that's the dent of my argument here, is that this court does not have to find in her favor because this very narrow issue of whether or not there's a 2506 appeal available here is the most important thing to focus on. During her argument, you had asked about the possibility of a final appeal order. Judge Lansinger, and I just want to stress to you that there's not even, we don't even have an action from which an appeal could have been taken, let alone a final appealable order. And that's why there is no subject matter jurisdiction in this particular case. With regard to the appellant's second assignment of error, as I've mentioned in my brief, first of all, everything having to do with an evidentiary hearing is entirely inapplicable in front of this court because that's the first we found out that she had any interest in arguing about some sort of evidentiary hearing. She had never mentioned it in her notice of appeal. It was not part of something that we would potentially have to argue about. With regard to her third assignment of error, there's a whole bunch of legal analysis in that assignment of error that never came up at the lower court level under any circumstances. All we had are letters that were provided by New Sunrise to Ms. Robertson. So the possibility of us having to attack those arguments or even address those arguments, even at the appellate level, is entirely unfair to the Mars Board. And for those reasons, I would ask that this court uphold the trial court's original decision. If you have any further questions for me, I'm happy to answer them. If you require any supplemental briefing on any particular issue, I'm happy to provide that as well. If nobody else has any other questions, then I'll just play the rest of my time.
Any questions? Hearing none, we thank you very much for your presentation.
Thank you.
And council, you'll have a brief rebuttal time of about a half a minute.
I would just like to emphasize that this is a all the elements for a 2506 appeal have been met. The Mars Board is a political subdivision. They did make a decision. It was a final decision. There was a request for a reasonable accommodation that was made, and that was their response. There was no, let's think about it, we need more information. That was a decision. And so we're asking that this court reverse the decision and remand it for an evidentiary hearing. There have been lots of issues that have been brought up, but Ms. Robertson has never had an evidentiary hearing on her reasonable accommodation, whether or not it was reasonable, whether or not she's entitled to one.
You're going to need to wrap up.
And for all those reasons, we request that the court reverse the lower court's decision and remand the case for an evidentiary hearing. Thank you.
Thank you. Thank you both for your presentations. The court will take them under advisement and issue a decision in due course. The clerk of courts will mail a copy of the decision to both of you on the day that it's released, and the opinions are also posted on the Ohio Supreme Court website. Thank you both again.